Good afternoon. I'm Russ Feingold, and I'm the president of the American Constitution Society. Thanks for joining us today for part one of a two-part series on how to reform the presidency. Donald Trump operated the presidency in ways that defied widely held assumptions about how a president might use and abuse the powers of the office, highlighting the excesses of executive authority and weaknesses in accountability that are actually built into our governing institutions. Now, he wasn't the only president or the first president to expose these dangers, but he did so unlike any of his predecessors. He was disregarding the norms of our democracy and weakening the institutions that support it. Recognizing that a future president might well choose to exploit these powers more skillfully and even to greater effect, we're here today to begin a conversation on how we can reform the presidency and build or rebuild some of the guardrails of our democracy. Building off the detailed roadmap for reform that Bob Bauer and Jack Goldsmith put forward in their recent book entitled After Trump, Reconstructing the Presidency, today's session will dig into what reforms are needed to protect the institution of the presidency from a rogue president, how to prevent foreign influence in our elections, financial entanglements, abuse of war powers authorities, and ensure that statutes like the Insurrection Act and National Emergencies Act aren't misused. And I also hope that you will come back and join us next week for part two of this series, when we'll focus on reforms that are needed for the Department of Justice and how to ensure that the department can act independently to pursue the impartial administration of justice. We have an all-star panel of experts with us today, and I don't want to take away any more time from them and what is sure to be an excellent discussion. So to get the conversation started, I'm going to turn it over to our today's moderator, Kimberly Atkins. Kim is a senior opinion writer for the Boston Globe and an MSNBC contributor. Previously, she was the first Washington, D.C.-based news correspondent for WBUR, and she served as the Boston Herald's Washington bureau chief. We are so glad to call her a friend of ACS, and she is with us today to moderate the discussion. Kim?
Thank you so much, Russ, and thank you to ACS for having me back to moderate what will be a great discussion about the book that Russ referred to was called After Trump, and ways to rethink and foolproof the presidency. And so joining us for a terrific panel are the book's authors. Bob Bauer is a professor of practice and distinguished scholar in residence at NYU Law School, and he's, of course, formerly White House counsel to President Obama. And Jack Goldsmith is the learned hand professor of law at Harvard Law School, and he is also the former Assistant Attorney General for the Office of Legal Counsel at the Department of Justice. In addition to the book's authors, we're also pleased to be joined by Secretary Jay Johnson, who is now a partner at Paul Weiss, LLP, and he was formerly Secretary of Homeland Security. And we're also joined by Hina Shamshi, who is the director of the ACU's National Security Project. Welcome to all of you, and thank you all so much for joining us. I want to start with Bob and Jack, and just before we get into the substance of the book, talk about why you wrote the book.
Jack, you want to kick that one off?
Sure. So thank you so much for having us today. We're really pleased to be here. Bob and I met several years ago. We come from different parts of the political world, and through a long series of events, we decided that we were going to write a book about the White House Counsel, which was the office Bob used to hold. And in the course of planning for that book, it was 2 or 2.5 years into the Trump administration. The day we devoted to that book, we started talking about all the reforms that would be needed when Trump left the presidency. It seemed to us like we were going to have congressional and executive branch engagement on rethinking the constraints on the presidency, akin to that which occurred in the 1970s after Watergate and Vietnam. And with that general idea in mind, we set out to figure out what we thought the main problems revealed by Trump were. And we tried to be very concrete and about what the solution should be. We tried to put everything in historical context. But basically, we think that there's a need for reform akin to the major reforms of the 1970s.
And Bob, you know, Trump's name is in the title, but reading the book, it's really clear that this isn't just about him. As Jack points out, you carefully examine history in coming to the recommendations you make. What's your goal here in putting this out now?
We'd hoped to, and we were lucky and successful in getting it out before the presidential election in 2020. And our view was the time was really ripe while Trump was in office, but some were looking to the moment when he would not be in office to begin thinking about a structural reform of the presidency and not have it, as you point out in the way we wrote the chapters, not have it entirely about Trump, but Trump as a galvanizing moment, if you will, who behaved in ways that brought out fundamental weaknesses and fissures in the constraints and norms that governed the presidency and the conduct of the presidency. And our hope was that this set of events, the presidential campaign, the look back on Trump, the potential he would not be there again in 2021, and this debate, once he was gone, could begin, is what we sort of hoped we could make of this writing experience.
Okay, well, I want to jump right into the substance of some of the issues that you look at in the book. We don't have time to even scratch the surface substantively, but we're going to give it our best shot. And I want to start off the discussion with the issue of emergency powers, and in particular, since we are joined by Secretary Johnson, to talk about one area that the emergency power was used, and that was with respect to the southern border. First, Jack or Bob, whoever wants to sort of lay out the problem and the solution as you see it when it comes to the use of emergency powers. And then I want to go to Secretary Johnson to get his thoughts about the southern border.
So I'll speak very briefly about that and very generally, because we engage elements of emergency powers in the book, especially the Insurrection Act, but I'll speak to the general problem, especially the one that President Trump invoked his emergency powers to try to fund the border wall. The general problem, and I'm speaking very generally because there are a lot of detailed problems, the general problem is that Congress has delegated very open-ended emergency discretion to the president based on the president's discretionary determination that there's an emergency. And presidents for decades now have declared emergencies when there wasn't really something that fit what we would think of naturally as an emergency. Trump did that as well. And once these powers are invoked, and there are, according to the Brennan Center, I think 115 or so separate emergency power authorizations in the US Code, once these powers are invoked, the president basically can do what he wants under the statutes. The original National Emergencies Act had a process to force Congress to weigh in and to maybe check the president every year through the legislative veto, but that was invalidated in Chadha. So what you have on the books are some very open-ended emergency delegations without any real congressional oversight. Now, I'm going to defer to Secretary Johnson. I don't think, in the following sense, I don't think these emergency statutes, most of them, if any, are directly implicated by what's going on right now at the border. But there is a huge general problem with emergency statutes.
Yes, and as Jack pointed out, it was invoked by President Trump as for justification for building the border wall. But I want to ask Secretary Johnson, isn't on the one hand it important to give president that authority given any number of exigencies that a nation can face and the need for a president to act swiftly, but how is that idea juxtaposed to the way President Trump used it for the border wall?
So before I begin, I may have an emergency right here in my office. My dog is whining because he wants to go out and nobody else is home. That could truly evolve into an emergency. So listening to Jack and Bob's opening comments, we could predict that post-Trump, there's going to be a lot of thinking about reforms needed to prevent abuses of power again. Jack said reforms needed after Trump. These are reforms, frankly, that were needed during Trump. it's a shame that those in Congress did not act to rein him in while he was still in power. We're going to have this discussion now about war powers, about spending authorities, invocation of emergency authorities, when we have in place presidents who are responsible, mature actors who appreciate the Constitution and separation of powers. When I was at the Pentagon as a general counsel, every once in a while we'd come across some restriction that had layers and layers and layers of regulations on top, like use of government vehicles. And when you could bring a family member in a government vehicle, things like that. It was micromanaged because somebody somewhere abused the use of government vehicles, and one person therefore made life difficult for the other 10,000 who would never even think of doing it in the first place. And that very often is what happens here. So the southern border, there is a provision in Title 42 of the United States Code that authorizes the president, the Secretary of Homeland Security, to expel people at the border for reasons of public health and safety. That invocation of authority, very plainly in my judgment, was used by the Trump administration simply as a way to drive down the number of crossings. And it was clear to me that they were never going to repeal invocation of that until some district court somewhere enjoined them from further invocation of it. That is the type of abuse of authority that one hopes would never occur. I mean, it never would have occurred to us in the prior administration before Trump to use that authority to regulate the southern border generally. And so I guess my bottom line to the question and to this general topic is something I've heard Jack say from time to time. The Constitution, the way it's structured in our laws, assumes a wise, mature actor at the top who will abide not only by the letter of the law, but the spirit of the law.
And that point, that the difference between rules and norms, it runs through all of the things that we are talking about today, and it's a central part in the book. Hina, I want to bring you into the conversation too, and also encourage others to jump in as we discuss. When you have sort of a similar issue that I put to the secretary, when you have this broad authority given to a president to be able to react to emergencies, including those that may, in the estimation of the president, present a security threat, is it important to keep that breath? And how do you reimagine it and bring it in a way to stop abuses like the one the secretary identified?
So first of all, Kim, thanks so much for that question, and to ACS for having me, and to Jack and Bob for writing a very, very useful book. Part of what I think is so useful about that book is that it helps us, again, because many of us are veterans of these debates over many, many years now, understand that some of these questions really require not just to focus on the particular personality of the kind of president we all hope we never, ever have again, but the importance of a system of checks and balances, a separation of powers, and where we have been on many of these issues, not just under Trump, but I think really importantly in key ways when we're talking about war powers, emergency powers, issues at the border as well, a deference, and one might even say an abdication of Congress's role with respect to checking the president. And part of what I think has become abundantly clear is that with respect to the Constitution and statutes under it that are supposed to constrain executive power and executive authority, those systems are really broken. And so what is useful about this discussion is to think about how do we fix it? Not just because of Trump, horrifying as he was, and we're still pulling out of many of the things that he did, but what are the ways that we actually impose real limits so that Congress, the executive branch, and I would add the judiciary are involved in enforcing the Constitution and protecting individual rights. So I'd love to talk about some more of the specifics. You know, we litigated the border wall case, and that ended up being a case about the appropriations clause, because President Trump, in declaring that emergency, appropriated funds that Congress had not allocated. But the kinds of reforms that we need are more structural. And I think among the sort of basic principles I look at when I think about structural reforms are how narrowly does Congress define the authorities that it agrees that the president has or gives president funding to apply. What are the definitions? What is the off switch? You know, we're talking about authorities in many instances that have existed for decades and can be abused. What are the off switch? What are the sunset provisions? And what are the safeguards so that Congress can actually exert its powers if and when, sometimes when, the president goes beyond them? And those are really welcome discussions, I think.
Yeah, and Jack, I want to get to that issue of reforms, but also ask it in a way that, you know, Secretary Johnson talked about the reforms that were needed aren't needed after Trump, they were needed during Trump. How do you craft policy proposals that are forward-looking enough that it is not reactionary? And what do those reforms look like in the area of something like the use of emergency powers?
Yeah, so that's a great question. Thank you. We crafted the whole book on that premise. And we agree with Secretary Johnson that it would have been nice to see these reforms during Trump, but that was unrealistic. And we think there's that it's possible now after Trump that we can, especially at a time when there's a president who's interested in who believes in separation of powers, who spent the bulk of his career in the Congress, who considers himself a constitutionalist. There's a chance now where we can have real reform of the presidency so that we have a better system in place when the next Donald Trump, whether it's a populist demagogue of the left or the right or however, when that person comes into power, that the system is better prepared for it. And Bob and I, in thinking about every one of the reforms in the book, and there are many, many dozens of proposals across more than a dozen different topics, we thought about this question very much because we were worried whenever you make reforms of the presidency, there are many examples in American history. The original independent counsel statute is a good one, where the cure was worse than the disease and where you were responding to a particular problem and you made it worse. So we tried to come up, and I'm going to get to the emergency issue in just one second. We tried to come up with rules that were forward-looking to anticipate the weaknesses that we saw, but we were very sensitive to self-defeating effects and the like. With regard to emergency powers, the general problem here is not emergency powers. We're really talking about Congress delegating open-ended power to the president, whether it's deemed emergency power or not. And doing so across an array of issues. The immigration statutes are full of this, where the Congress just gives the president broad discretion about how to act. And presidents before Trump, not always, there was controversy about both President Obama and President Bush about how they exercised delegated power. But President Trump was more worrisome in this regard. And the basic problem is this open-ended delegation. The other problem, as he has suggested, is that Congress is not in the game very often, and it doesn't engage in its oversight responsibilities. So the way to do this is through structural reform. Congress, in whatever areas need reform, has to tighten up the rules. They have to be a little bit more specific. They can do that on a one-shot basis. What was mentioned about sunset statutes and forcing Congress back into the game to check an exercise of delegated power, whether it's an emergency power or a broadly delegated power, hugely important. Congress by itself has not shown itself capable of regularly engaging and reviewing what the president is doing under its delegated authority. So if there's a mechanism like a sunset clause or a limitation on an emergency power to force Congress to come back and reauthorize and reconsider, that is absolutely vital to all of these areas, we think.
So I just want to note two things. I forgot to say at the beginning to our audience that if you have a question, we will save time at the end to answer as many of your questions as we can. If you want to submit it, please submit it using the chat function on Zoom. Use the chat function. If you use the Q&A function, I won't see it. So use the chat function to submit those questions. I want to move on to another area that Bob and Jack address in the book, which is war powers, in part because I know Secretary Johnson will have to leave soon to deal with other obligations. He's very busy, but I want to give him a chance to talk about this too. I know as a reporter in Washington, D.C., one thing for the entire time that I've been here has been this ongoing discussion about war powers and the Congress's power versus the president's power, as several presidents have sort of extended the life of authorizations for the use of force, for example, to justify a lot of military actions. And there's been calls to either rein in AUMFs, rescind existing ones, force Congress to come in and grant new ones. And so I want to really start from there as we're looking at this issue of war powers to Jack or Bob. Sort of how do you see the problem? How do you outline the issue that your reforms are seeking to address?
I'll take that one because this is the way Bob and I have allocated these issues. I'm sorry to be talking so much. So there are a lot of issues here, and I'll be brief because I want Jay to be able to weigh in before I know he has to go soon. There are two clusters of issues. There's one, the so-called war on terrorism that's been going on since 9/11, almost 20 years now. And the statutory framework for that growing out of the 2001 authorization to use military force. There's now, amazingly, there seems to be a real consensus on both sides of the aisle and apparently in the White House that there needs to be reform of the statute. This is important for so many reasons because three presidents now have interpreted this statute increasingly broadly to basically constitute all sorts of engagements around the globe. Congress has gone along with this on the sly with appropriations, but they have not re-engaged the basic authorization. And we believe that they should do so, and I think that they will do so. The key things there are defining who the enemy is, defining who associated forces are, and having a sunset clause. Congress needs to commit itself to re-engaging on the scope and scale of the war as necessary every few years. And then just very briefly, there's a broader issue about other war powers of the president and the war powers resolution from the 1970s, which has been basically a failure for many reasons. And we have several proposals in the book drawing on Senator Biden's proposals from the late 1990s about how to reframe and restructure the war powers resolution, narrow some of the more what we view as extreme presidential war powers, but in ways that we think allows the president to keep the country safe, but would not permit some of the more extravagant open-ended uses of war powers.
I want to go to Secretary Johnson next, but I just want to point out that these powers are used not just to necessarily start warlike or military actions, but for example, President Obama used it for humanitarian intervention in countries like Libya. They're used in a variety of ways. So what would you like to see happen with the AUMF authority and war powers more broadly, Secretary?
War powers, the debate about war powers, the understanding of what the president's war powers are is essentially broken. As Bob knows, President Obama made clear to his national security lawyers that when it came to committing the armed forces into hostilities or counterterrorism operations, lethal counterterrorism operations, he preferred that his authority come from a statute. And when I was general counsel of the Department of Defense, we made the 2001 AUMF work against the Taliban, against core Al-Qaeda in the Arabian Peninsula, and the Al-Qaeda affiliated elements of Al-Shabaab. I worded that very carefully. And I believe, and I will always believe, that was a very sustainable, reasonable interpretation of that statute. Since then, it has been interpreted in much broader ways to include the Islamic State and just about every other terrorist organization on the earth. No way Congress intended that in 2001. In the meantime, because Congress has essentially gotten out of the business of authorizing armed conflict. The 2002 AUMF was the last one. The president's Article 2 authority is perceived to have grown. When I went to law school, the common understanding was that presidents could act if there was an imminent threat to the nation without a congressional authorization. That authority, frankly, expanded in 2011 with an opinion written by Jack's old office, OLC, that said the president had the authority to commit the armed forces anytime there is some national interest implicated. And so long as it didn't rise to the level of a war in length and in scope. Congress takes a very different view about what the president's constitutional authority is. Congress takes the view that they can rein in a president with the invocation of the War Powers Resolution, except when it comes to imminent threats to the nation. So there's a huge disconnect between the perceptions in the executive branch and in the legislative branch about exactly what the president's authority is. And I don't know how that's ever going to get resolved. It's not necessarily something a court would want to get involved in, because the court would probably see it as a political question. So those are my thoughts.
All right. Well, I really appreciate you sharing your thoughts and joining us today. If you need to jump off, we understand.
Thank you. Thank you.
And so Jack, I want to go, I'm sorry, Hina, I want to go to you with that issue, with the broadening of the presidential authority. I saw you nodding as the secretary was talking about the OLC determination. How do you see this issue framed?
Yeah, I was nodding in recognition of that OLC determination, which was controversial to say the least at that time. How I see this as is to try and step back a little bit. You know, what are we actually talking about here? And what we're talking about here is that we have a country that has a muscle memory for getting into wars and conflicts, but not very much of a practice of getting out of them. And that's been happening for 20 years now, right? In an earlier era, with the War Powers Resolution of 1973, Congress sought to limit the executive's really quite expansive claimed authority to engage in this kind of conflict, with a statute that ended up being read by the executive branch as license to use force. And so now we have a president, President Biden, who apparently must have read Jack and Bob's book or responded to our advocacy or something along those lines, who has said that he wants in his interim national security strategy to end what he calls the forever wars, right? And so thinking through what that actually means and what the core components are and the kind of structural reform, I would say this. One is that you know, Jack's referred to the 2001 AUMF, and Jay talked about interpretations of it that went far beyond what Congress intended at the time, including during the Obama administration. And so we have currently on the books the 2001 AUMF, a 2002 AUMF that authorized action against the Saddam Hussein regime in Iraq. That is not really authority for anything, and there appears to be increasing support in Congress to just repeal that. We also have, as a core component of this, something that Jay was alluding to, which is the expanded claims of authority to use lethal force outside of recognized armed conflict, not consistent with what Congress has authorized. And so among the sort of issues that we're going to be concerned with and that President Biden's going to have to deal with is ending the 2002 AUMF, ending the 2001 AUMF, and right now there's a debate, the sort of views appear to be an assumption that that's going to continue in some narrower form, but I would argue that's just part of the muscle memory of not necessarily knowing how to get out without actually looking at what's necessary. And then for the structural reform, I think Bob and Jack have some really helpful proposals. I would tend to go further, perhaps unsurprisingly, than they would. So I would want to build on some of their proposals with really strong sort of assertions of what Congress's role is and what the president's role is, for a definition of terms that are precise so that clever lawyers in whichever administration can't come and rewrite and end up with us in endless wars again. A switch so that the authority terminates and Congress either has to vote on it or a president has to come back and get authorization, which, by the way, Congress throughout our history has been really all too willing to provide. The kinds of constraints that limit against broad-ended AUMFs going forward, the criteria, how will we know a conflict is at an end? And those, I think, are just really important structural changes that we need to see.
And I'm going to throw it back to Jack, because I want you to talk about some of the reforms you propose and respond to Hina about some of the areas she thinks that can go further.
Well, we did propose some of those restrictions. We proposed that Congress define what the president's Article 2 powers are and the limits of those powers, drawing on Senator Biden's definitions. We suggest a set of definitions that would be as tightly drawn as I have seen in any proposed legislation about what self-defense is. Those definitions, we believe, would not permit all of the assertions by presidents of self-defense in the last 20 years. It would narrow that. There's going to have to be a realization in Congress you're never going to get any president or executive branch to sign off. And frankly, Congress is not going to sign off on restrictions of presidential powers that would not permit the president to act in self-defense. The definition is going to be, the debate is going to be what counts as self-defense. We provide a fairly tight definition of that. We also propose, and there will be debate about this, that humanitarian intervention is something that the president should not be able to do without express congressional authorization. This is not to say that there aren't times when humanitarian intervention isn't appropriate, but since it's so far from the core of the president's Article 2 power and self-defense power, we believe Congress must approve that before it happens. We have enhanced notification requirements. We have a ramped up 60-day requirement. We do have a sunset provision, which we think is very important on the authorization to use military force. It's hard to impose one more generally on uses of force, but the president can't. We do try to tighten up the circumstances in which the president can use force without congressional authorization for more than 60 days. And we tie it to funding restrictions. So we are serious about constraining the president's unilateral powers, but there has to be a realization and I actually think that there's not a majority in Congress that would ever want to go further than that. The question is, will they want to go that far? We believe that there's a chance that they will.
And Kim,
And I go ahead.
I just wanted to just mention one other thing, which is we also have some proposals on constraining presidents' resort to nuclear power. And I think that's an important proposal that we make. And when we were talking about emergency powers, suddenly dawned on me, we ought to just mention, I think it was briefly mentioned, the use of force within the United States, deployment of force under the Insurrection Act is something that we also believe needs to be reformed. You recall the concerns about what Donald Trump might have done, particularly in the service of his re-election goals, to use troops. There were concerns about that. It didn't happen, but it brought up the fact that this is a statute that's in desperate need of revamping. And also, again, with a view toward bringing Congress into a significant oversight and consultative role.
Okay. I appreciate that. I want to move on to another topic in the book, which is foreign influence in our election. And I will throw it back to you, Bob, after I just sort of, in thinking about this, we're talking about this in a broader way, not just focusing on one administration, but when it comes to foreign influence, two things stick out. One is the Russian interference in the 2016 election, and the other is Ukraine and the events leading up to President Trump's first impeachment. So how do you focus and address this issue and do it in a forward-thinking way when you have these major past events looming over you?
They should be bells that are ringing in the night. It's not the first time that a president was alleged to have, and certainly in Richard Nixon's case, shown to have engaged in a strategic political arrangement with a foreign power seeking to influence an election on his behalf in 1968. He wasn't a president at the time, he was a candidate, but he did that in negotiation with the then South Vietnamese government. And then, of course, we know from the last several years, whichever side of the debate you may be on, that our intelligence community has repeatedly warned, in the Trump as well as other administrations, that we're going to see more direct involvement, sometimes indirect, more indirect than direct, sometimes more direct than indirect, by foreign powers to try to influence the outcome of American elections. And so the time has come to step back, take a look at the experience of recent years and see what reforms might be appropriate. We suggest some reforms, some of which piggyback on existing notions that we try to refine. For example, in 2016, when the Russians contacted the Trump campaign to offer assistance, the Trump campaign did not notify federal law enforcement. We believe, building off of a proposal from Senator Warren, that those sort of contacts should be reported. And we build that proposal out in some detail with the basic Warner proposal as our structure, but with some refinements of our own. We also believe that, and this has also been proposed, that we ought to bring an end to this debate about whether the mere provision of information by a foreign power to help a presidential campaign in the United States is somehow not a political intervention, somehow not a contribution. You recall the debate over whether or not opposition research supplied by the Russians would constitute a contribution under federal campaign finance laws. I think that's easily addressed. I think the most important of the reforms, or at least essential reform that Jack and I proposed, is that we have to strike at these broader strategic alliances that could be formed between a presidential campaign and a foreign power, where there's an understanding, certainly one that the evidence suggests the Russians wanted to reach with the Trump campaign, and the Trump campaign shows quite a bit of interest in and pursued, at least up to the point of that Trump Tower meeting in June of 2016, that the government of Russia was prepared to be helpful to the campaign in a sort of directly partisan preferential way, and the campaign was prepared to welcome that support. And the question is, could something be done by amendment to federal law to prohibit those kinds of strategic alliances? And we believe there is, and we set that proposal out in the book.
So I want to go to Hina and talk about this, but from the idea as well as somebody who's watching these events, obviously the Russian interference and the Ukraine event got a great deal of attention, and understandably so. But I am often asked, well, what's the difference between President Obama telling the Russian president, hey, if you wait until after the election, I can have more flexibility in dealing with you on policy issues, and crossing the line into something else, and sort of speaking to some of the reforms that Bob just mentioned.
So I will say that in response to your question, as much as I can give it, really important to keep in mind how any reform would apply to any president. This is not an area on which I work specifically, and I try and make a practice to sort of talk only about things I'm an expert in. So, unless there's sort of more of a direct civil liberties or rights issue, I'm very intrigued to hear about the proposals and to have read about them.
So let me ask this question then, because through, like I said, a through line through our discussion today is this idea of the difference between laws and norms. And one question that I have very generally is, yes, you can put a lot of proposals forward, and it's necessary to revisit proposals to reform laws when we see that it's needed. But isn't it equally important to instill norms and to, as a society, demand that our leaders adhere to norms in a way to strengthen the office itself and also Americans' faith in it? So is there a way, how do we rebuild norms in any of these areas, Hina?
So I think certainly, especially after the last 4 years, the importance of norms has become abundantly clear. I would argue that norms were being flouted in the post 9/11 era with other issues as well, right? And what it then comes down to is when norms fail. So what am I talking about? I'm talking about abuse of war powers and war authorities in violation of domestic and international law. I'm talking about surveillance authorities post 9/11, just a whole range of things that, as we're looking ahead to the 20th anniversary this year and trying to grapple with what are the costs and consequences of approaches that we have taken, born, I think, most often by communities of color in this country who are deemed a threat and enemy, part of what President Trump sort of highlighted yet again. I think the importance of ensuring that when laws are not adequate to actually protect and safeguard constitutional rights, when the kinds of structural reforms that we're talking about are necessary, then that's a time to act, right? And and again, part of what's so helpful about what Bob and Jack have laid out in some core areas are, here are some real basic and sound principles and what can be done to make them happen. And I do think, Jack was talking about not being sure about whether there is congressional appetite for the passage of certain particular elements. And I think that's very much been the case for a significant part of the last, given the issues I've been working on, last 20 years, which has meant an abdication of Congress's role, which has meant lack of meaningful oversight, which has meant constitutional violations, separation of powers violations. But I do think that in part because of the Trump era, and in part because some of the events of that era, such as, for example, the recognition of the consequences of our wars abroad with respect to militarized policing at home, when we're looking at the response to the summer of racial justice protests, people have drawn these connections. Polling shows that there is a lot more appetite, including from veterans, for an end to war-based approaches, just to take that example. And there is a lot more appetite from members of Congress to discuss and address and practice oversight. And that, to me, is part of what is hopeful now.
I want to, in making sure we leave time for some of the many questions that we've already gotten in so far, quickly look at one other area of the many areas in the book that Bob and Jack address, and that's financial conflicts of interest. So we know that presidents and vice presidents are exempt from the core rules regarding financial interest, and including things like divestiture of certain divestiture of assets that may affect rulemaking. And we also know that there are norms in place. Up until 2016, it was the norm in modern history for presidents to do things like release their tax returns when they were candidates. So how is the problem as you outline it, and what are some of the solutions you pose in the book?
You correctly identified the problem here, of course, which is that we have relied, for example, on a core requirement of financial conflict of interest protection, on a norm, which was that presidents, like presidential candidates, would release their tax returns. And that's certainly a conflict of interest transparency requirement. And that didn't work out this time. For 4 years, this president, and then in the period of time before that, when he was a candidate, refused to release the returns. And on a specious excuse. I don't think anybody doubted that he wasn't under audit for the entire rest of his life. And moreover, even if he were under audit, as he said, he could have released the returns. He didn't. And so it became clear that the norm was failing, because certainly his election in 2016 suggests he didn't pay a heavy political price. The Congress could have put more pressure on him, did attempt eventually to secure the returns. But at the end of the day, we didn't get the returns. They may emerge from the investigations taking place right now. Anyway, to make a long story short, we believe that the returns ought to be, as one piece of other conflict of interest regulations, subject to mandatory production. We lay that out. We think it ought to apply to major party nominees as well as to independent candidates. We think it ought to apply to members of the president's family if they're appointed to senior executive branch positions. We also think that the audits that the IRS routinely conduct of presidential tax returns since the Carter administration ought to be released to the public. They never have been. And we also want to make sure that Congress has the legal authority in the event that the president's returns are not produced to successfully sue to obtain them. And then very, very quickly, there are a series of other conflict of interest requirements we think are important. One of them is to genuinely provide for the absolute separation of the president from his or her business interests, to place the reporting requirements for those interests, and there ought to be reporting requirements for those interests, to place those requirements on the businesses themselves, so that the president cannot have information about the business and therefore be expected to account for those business interests. The president has to be completely separated from involvement in his or her business interests. For that reason, we don't think presidents should be able to establish a blind trust. We think we ought to know what holdings the president has, what assets and income a president is receiving. And so there are a series of reforms like that. And last but not least, the Emoluments clause enforcement that's been missing in the last several years, where presidents are not allowed to receive benefits from foreign governments without congressional consent. Again, Congress has been quiet about that. And we make a proposal to provide for enforcement of the constitutional prohibition on foreign emoluments.
Hina, I want to give you a chance to say anything that you might want to respond to that before we begin taking questions.
Sounded all very good to me, so let's take questions.
Okay, very good. Thank you for that. So one question that we got, and I'm going to paraphrase it a little bit because it's really long, is that while the Trump administration highlighted ways in which the executive authority can be very broad as interpreted under Article 2, there currently calls for the Biden administration to adopt similarly broad views to address crises that they call public policy, that call for public policy responses. So how do you reconcile, essentially? We were saying that the power of the presidency, it has grown so much under Trump, or he expanded it. Well, right now, there are calls for people to say, well, use that expanded executive power to address all these other issues, whether it's the pandemic, whether it's racial justice, whether it's other things. So how do you reconcile those two ideas?
I'll take that. So this is just an example. You're basically referring to the idea that President Biden is now going to be under a lot of pressure to achieve his policy goals by exercising delegated power from Congress very aggressively in immigration and other contexts. And isn't that the very broad exercises of power that we're worried about in our book? And the answer is yes and no. We did not address this issue. We thought for a long time about addressing this issue. This is a very hard question that we could have taken a book on. Namely, it goes to the core of administrative law and the role of the courts and the president's relationship to the court's relationship to the president. And this gets into the Chevron doctrine and the non-delegation doctrine and a whole cluster of issues that Bob and I just did not take on in this book at all. We noted up front that President Obama was particularly aggressive in this form of executive power, perhaps more on average than President Trump. But we did not take that question on here. I will say that it's just another species of the issue I referred to earlier, which is we basically have a bunch of old delegations on the books from Congress because Congress has gotten out of the game of lawmaking. We have a bunch of old, and as long as Congress is out of the game of lawmaking, then policy is made in this country by presidents seeking to achieve their policy goals through delegated power and courts reviewing those powers. And that is a huge, it's not the way the government is supposed to work. But the government can't work better. This problem ultimately can't be fixed unless Congress decides to update legislation to weigh in more regularly. I do think this clash between the Biden administration exercising a delegated power through administrative agencies very aggressively and a more conservative Supreme Court that's been moving in the direction against welcoming this kind of broad delegation to the president. It's going to be one of the consequential clashes of the Biden administration. So we don't really address that. It's part of the same problem we do address, but we don't address that particular one.
I want to give anybody else a chance to respond before I go to another and related question. Okay, so to Jack's point, we got a question, and again, it was long, so I shortened it to this. To what degree do you see what seems to be the current Supreme Court's strong pro-executive tilt to be a threat to your recommendations for reforming the presidency? Any of you can feel free to jump in on that.
I will just point out, and Jack will certainly have views on this. I think our book attempts to take into account the constitutionality of specific proposals that we lay out there. I think in a number of cases, again, I don't want to engage in predictions here. It's sort of hard to say what shape these battles may take, and therefore the degree to which the court may be drawn into resisting some of these reform proposals in whatever form they ultimately take. But I do think that we have made an effort to look seriously at proposals that are configured around constitutional doctrine comfortably enough, existing doctrine comfortably enough, that we think in a number of these cases, like the ones I just discussed, by the way, foreign state influence and conflict of interest requirements, they would pass constitutional muster even with this court. But Jack, maybe I'm being overly optimistic.
No, I think that's right. I would just add the one reform I believe that we come closest to the line of where the Supreme Court, or in most tension with the Supreme Court, is we propose a removal restriction, a for-cause removal restriction on the independent counsel. And this is not something, and this is something that the Supreme Court, if it ever got the issue, might not uphold as constitutional. Having said that, we hope that it would never come to that, and we hope that a for-cause removal provision, if enacted, can still operate and generate norms long before, and hopefully never, for a president to fire a special counsel, which, by the way, even if it were unconstitutional, it would still, by the fact of being on the books long before it got to the Supreme Court, it would still raise the political stakes for the president in firing a special counsel. So that is the one reform where I think this is a genuine concern, but I think it's a distant concern.
Okay. I will say, Jack and Bob, if you do write a book on the other aspects and get into things like Chevron authority, I'm a total admin law nerd, so I would be happy to come back and moderate a discussion about that too.
That's great.
I'm gonna move to another question. How effective is congressional oversight when one or both houses of Congress is controlled by the party of the president? Anyone want to jump in on this? Hina, do you have thoughts about that?
I think we'd all, or at least many of us, would like to live in a world where congressional oversight does not depend on the political power, recognizing that obviously there is more likely to be deference given to a president. But in important ways, oversight needs to be nonpartisan. And needs to be from that starting point of checks and balances. And you see what happens when, for example, Congress either deferred, for example, with respect to President Obama on assertion of war powers, or with respect to President Bush on similar things, or other assertions of powers in the post 9/11 era. Our system does not work well. And part of what ends up getting missed from all of this, we haven't really discussed here the role of the judiciary as much as we might, and as much as I think we should. And especially when we're talking about emergency powers or issues that are called national security or foreign policy. Too often there is, I think, an impulse on the part of the political branches to write the judiciary out of its role. And where I think that can be really problematic is when that means that the executive branch acts in violation of individuals' constitutional rights, the congressional oversight breaks down, and the Supreme Court or judicial doctrines mean that there is no access to the courts, whether because of immunity or secrecy or other threshold doctrines. Then you have a really core component of the relationship between state and individual, and how power is exercised with accountability, that can break down. And so I think the other area in which we've gone really too far in the last 20 years is with respect to lack of judicial involvement in some of these core areas. that can vary with its specifics, but I will say that in terms of emergency powers, right, not so much war powers, but in terms of emergency powers with an impact on constitutional rights, the courts have played a more meaningful checking role, especially when those emergency powers have been exercised domestically in violation of constitutional rights, and that has been critically important.
And just a couple minutes left here. I want to put that issue to Bob and Jack too. That was going to be my next audience question: is the problem branch in the future more likely to be the judiciary than the executive? Can you speak a little bit about that question and Hina's concern about the judiciary?
I'm not sure. Did you say whether the judiciary would be more of a problem than the executive?
The question that was submitted from an audience member is the problem branch in the future more likely to be the judiciary than the executive? And I took it to mean that one of the issues is having the upholding and or striking down some of the provisions that you're talking about and the concerns that Hina addressed.
So I'll just say that I just don't. So we focused on executive power. We said that we could have written a book about congressional power or judicial power. We said at the beginning of the book that we basically take the state, the kind of degraded state of Congress and whatever the judiciary is as we find it, and the precedents as we find it on that side. And we try to focus on what kind of reforms of the presidency would best prevent some of the abuses that we saw in the last 4 years and going beyond that, before that in some issues. Again, I think that, it depends on how the statutes get drafted, and we try to be very precise about this, but I think except on the issue of the removal statute that I mentioned, I don't believe there's also a question about the obstruction. We propose an obstruction of justice statute for the president. I think we may talk about this next week. That does raise constitutional concerns, but we think we drafted it and proposed it in a way that would meet those concerns. So the judiciary might be a problem for a whole bunch of things, and it's certainly, I do predict it's going to be a big problem for the Biden administration's administrative law program. But with regard to our reforms that we propose for the presidency, I do not see it as an issue. Whether it's an issue for the Biden administration more generally, perhaps it will be. I think it actually will be, but I don't think it is for our executive branch reform proposals.
All right, well, that is all the time that we have for today's discussion about the book, After Trump, Reconstructing the Presidency with Bob Bauer and Jack Goldsmith. I will remind our audience that both Bob and Jack will be back to discuss other aspects of the book, specifically on how to reform the Department of Justice next week, and you can sign up for that on ACS's website, the same place that you signed up for this event today. On behalf of ACS, I would like to thank all of our panelists, Jack Goldsmith, Bob Bauer, Hina Shamsi, and Secretary Johnson for joining us today. And I hope you all have a great day and be well.
Thank you very much.
Thank you very much.
Thank you.